Hey y'all, we back with another reaction. Hope everybody's doing good. Don't forget to hit the like button and subscribe. We want to get into our content this morning, evening, noon, night, wherever it is in your country. Oops, gag order. Emotions in Bryan Kohberger hearing raised many questions for the family. Now, that had the family attorney it's making it about them, and right now it's not about them. It's about the Kohberger and state, and he want to explain that he can't a lot since there's a gag order. It's a lot of things he can or can't say to the family, to his clients. So let's listen to this right now. It's Kohberger and his lawyer. But in this case, it's the family lawyer trying to be complicated. But it's about Kohberger and the state. She's smiling about. Okay, yeah, I can't hear him. So what I'm gonna do? See, can I connect y'all? Okay, hold on, y'all. I'm gonna back it up. Let me stop this.
Hey, John Asraf here from the smash hit movie The Secret. And a lot of people love the movie because of the law of attraction, right? But it didn't work for a lot of people.
Okay, hold on, y'all. I don't know what's going on here, but it's not me. It's not me.
Non-dissemination order.
I'm gonna take it back.
This hybrid approach is challenging. Okay, so let's get on the record, please. We are now on the record. This is State versus Bryan Kohberger, CR 29222805. We're here for a hearing on the Exalvis.
Hold up 1 second, y'all. Let me see. Can I get y'all one that playing a little louder? Because I can't hear. And I do have another one. Hold on. I think it get a little louder right here. Hold on for a second. Okay, let's try it again. But it's not my device, it's theirs. So let's try to run it again.
Family's motion to appeal, amend, and or clarify amended dissemination order that was filed back on February 3rd was was delayed because the media sought some relief from the. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of names, Kaylee's name and Raymond's name, and I want to explain that. I was up all night, really ill, probably food poisoning, and I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and wanted to address it.
Excuse me.
I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is not unusual. But reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website, and it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
If you allow me just a minute or two to get sorted out here.
take your
Appreciate
time.
it.
Take your time. Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I first want to start with the procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, It was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense, and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties ascribed above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing the Idaho Rules of Professional Conduct in that issue, I would have prepared, but only having a 3-hour notice didn't allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd, and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed the motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as.
Can I interrupt you?
Yes.
There's no dispute about that.
Exactly.
Okay.
Your clients are not parties. The only parties of this case are the state and Mr. Kohberger. That's clear. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
Exactly.
So let's get into the actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tapp case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Barner versus Delahanty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Slav was a defense attorney.
There's a huge government
Yeah,
scam.
yeah. He's saying too much about other cases and not about this case. Can't compare other cases with this case. This a different state. Gosh, sorry about the commercial, y'all.
Prosecutor's actions. And speaking to the media, Shepard v. Marshall, Maxwell is a trial publicity regarding the
And
prosecutor's
Bryan
actions.
sitting here gnawing his head, y'all, back and forth, like he practicing his law firm.
Prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me. If you'll read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me because I'm not involved in the litigation. She also says that.
Can I ask you a question about that? Because I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the.
And the judge is right. His clients are witnesses. So the gag order goes uh, for them also. Judge right.
And I can address it, Your Honor.
Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution, nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger.
But then also, the young man who's standing here talking, the prosecutor did have at the beginning, of course, he didn't have anything. They understand that they didn't have any paperwork. Kohberger didn't have anything, but the prosecutor team was ordered to give information to Kohberger attorney, and that's what the prosecution team did. So I don't know what he's I don't know what this man talking about.
There was a grand jury that was being impaneled, and common sense, we figured it out because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Gonzalez family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the...
Well, the prosecution team won't want to speak to a Kohberger family. Why would they? They going against him. Yeah, he just wastes 10, 20 minutes of the court time.
Victim statute. I just handled that matter in front of the Lori Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, they've never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family as well as myself. The other thing is that if the victims can say whatever they want during the free speech and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, and I'll give you an example.
Is that true?
That's right. Well, I agree now, because that's
See,
not,
this dude right here, y'all, is don't like to listen. He don't want to listen. So whatever you say, the judge gonna have to stand on his word on this dude standing right here, the attorney for the family.
the tone of the Zoom meeting.
Well, we're not talking about the
Okay.
tone. I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I ask for clarification, now understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, my victim, the family asked, has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion? Right? So then I'm already governed by the Idaho rules of professional conduct. And if
I'm glad you're acknowledging that.
no, well, every attorney is, Your Honor. I mean, it's not,
Thank you.
every attorney is. So the idea that I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge.
Wait a minute, hold up, dude. You can't come in and change a gag order. You can't. It's no way. All right, y'all, just listen. He trying to make arrangement to change a gag order. No, it's not gonna work for nobody. Neither one of the side like that.
Another rule might pop in, 8.3, I think is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the probability. But the probability I don't even think applies to me in this anyway. Because if you look at it, it says it applies to a lawyer who is participating or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3, the rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this: rule only applies to lawyers who are or who have been involved in the investigation or litigation of cases and their associates. If I'm not a party to the case, I can't be involved in the investigation or the litigation of this case in any way. So I would argue that the trial publicity rule of professional conduct does not apply to me as well.
Help me understand what you think you can't say that you've already been saying.
I have no idea. I have no idea what it is.
You've been on the media and you've had interviews. So I'm kind of wondering how do you feel that you've been restrained in any way
Exactly.
with this order?
I
Thank
think
you.
you're not seeing what the point is. What the point is that
I
the
understand.
court has issued a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney, when an attorney who's walking down the street could offer up his opinion in any way, it also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that they could explain things, so maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking
A gag order is a gag order. You can't just come in and just change the process of a gag order only just for a family and just for that particular attorney. Come on, dude. Come on. He's not taking away your voice. It's just part of a gag order.
Voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case.
What?
The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Gonzalez family. And I think it stems from, initially, we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on,
That is the purpose of a gag order. That's the purpose of the gag order. What it's doing now, keeping it from getting out to the public. You talking, this young man is talking around in a circle. Whatever happened can get back to the prosecutor. Even if the prosecutor team didn't agree with this young man, they can't change what in process of a gag order.
it has been, we are the enemy. And that's how we feel in this.
Okay,
And
that's how you feel. They're not worrying about how you feel. Because that's not part of how you feel. It's not, has nothing to do with a gag order. So his emotion need to calm down a little bit. See, that's, they said from the beginning, this is what this case would do to you mentally, physically, and emotionally. And that's what it's doing to this attorney, family attorney.
so me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way. It's just an attempt to shut the attorney out and shut the family out, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
Well, I don't know what's in all the investigation, obviously, and a lot of us.
But he had, okay, Judge, this man had plenty of time, the family had plenty of time to get themselves in position for what's about to happen. Now he gonna wait until y'all put a gag order in process, and now he want to talk to the family. That's their family fault. They knew what was going on with Bryan from the beginning.
Don't know and probably won't know
well,
until the trial.
and the other thing,
Well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly would be witnesses in that process of sentencing. Now, that is not post-conviction technically, is it?
it's the,
He doesn't
if your goal
listen.
is fair and impartial.
He don't listen. He don't listen. He's saying, he's standing here repeating himself. He's repeating everything he just said.
Right? That's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process.
That's right.
So I have that job. I have a job of protecting and preserving the First Amendment
That's right.
and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about.
Oh, thank you. And you know, he just said, the judge just said what I just said, y'all. Just explain to y'all. This what's going on. But if things don't work his way, what I got a somehow something telling me that attorney right there is gonna work around where he's gonna talk. He had plenty of time to get himself in process for this procedure. Now it's up to him now.
just hearings about.
And as an officer of the court, I can tell you, we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client?
Regarding the facts of this case, no, they haven't.
All right.
How things occurred.
And everybody's gonna have a chance to weigh in on this, and I just, you're helping me understand what the issues are, so thank you.
What is, so that's really the issue here. I mean, and this is an important ruling, because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that, part of the argument is that,
In fact, I know I have the authority to do that.
well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay,
So
that's hard to accept, but.
we're not witnesses in the case, we're not involved in the investigation, we're not involved in the litigation. I can't file any motions, I can't subpoena anybody, I can't cross-examine witnesses, I can't do anything.
And in other words, what this attorney wants to do is get all the information from the prosecutor team and go over there and tell the mamas, the Bryan family what's really going on, which this is their job. They already did transfer. It's not about him. It's about these two teams right here. They have already processed this information that he's talking about among them two. It's not about the third man.
So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is.
We're talking about your
That's right.
speech.
That's right.
Not your client's speech.
But that is my
That's
speech. That is part of it, though.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
That's
That
right.
is distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said we thought the judge was crazy, and I said the judge was crazy, I can't be, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice, where I said, the judge is crazy? Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, I would be Idaho rules of
You know
professional
what, y'all?
conduct.
I'm gonna skip this a little bit because he's standing here. And I'm saying the same thing, and he's repeating himself. Okay, he's not gonna win this because it's about. This is a death penalty. This is prosecution, Bryan, not you. Okay, let me skip it a little bit. He wants somebody to get the information here. I'm just skipping a little bit.
I don't know if that's Mr. Thompson or Mr. Rowley.
Don't be me. Can I have one moment, Your Honor?
Certainly. Thank you.
If I may,
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients would make public and compromise the integrity of the investigation. For him to say that we provided more information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear.
The L'Oreal Pumping Water Cream. Look at this bag.
Now, I knew he wasn't being honest with it about the prosecution team because I know they did their job. Now he's making this bigger than what it is.
If I could speak to that, Your Honor.
You'll be able to
Thank
come
you.
back in after you hear the other
Thank
arguments.
you.
Mr. Evans, go ahead.
Thank you, Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult
right.
is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Grace repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Gonzalez families are potential witnesses in a trial, or more specifically at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepard, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most, tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8.
Exactly.
With that, I'll stand for questions.
Thank you, Mr. President. Yeah, do you think that would be helpful to just, and I asked Mr. Bryan this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive
true.
way in this case to address and preserve.
Because see, and they got to realize that the prosecution team got to protect the witnesses that they have against the dude, against Bryan Kohberger. I mean, come on now, come on.
Right to a fair and impartial trial.
Right. Can you go back? You mentioned this about the standard, particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, click here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepherd to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Age 49 to
See,
63 and not able.
the other guy, the other attorney for the family, got to realize we already done been through the process. He trying to take the judge through. We ready to rock and roll with this here.
Thank you, Mr. Evans.
They need to fix his mic.
Judge, I think a lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case and therefore don't fall in 3.6, would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation. And therefore you would fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just does it fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. we also agree that at this point, the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here, where we all get a chance to speak. You know, the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's trying to put the media into a frenzy and send this case to the firing squad or probably something like that. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. I haven't seen prosecutors try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions?
Well, that's up to Bryan. Open up his mouth. Y'all got to get Bryan to talk. Bryan feel that if he don't say nothing, then it ain't nothing. But Bryan, if don't want to talk, then that's y'all.
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed.
I guess the first thing I would want to address is the
Oh,
prosecution's
God, not
idea
him.
that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred. And they still have made no contact as far as investigating and interviewing the victims' families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is, everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in the court right now.
Because you're the one who brought me in here because of the non-dissemination.
You brought yourself in.
Yeah, well,
You're the one who filed the motion.
I did file the motion because the non-dissemination order is
I
unconstitutional.
understand. I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why
Because,
would you say that?
well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once
But
again,
they, well, the Supreme Court has said they have standing to come into the court and address issues. So,
yeah, that's completely separate. They're not.
well, I know it's separate.
Okay, so.
I also respect your position.
Thank you, Judge. You keep your word, honey. Don't let him tell you what to say. He he put me to sleep. Okay, but y'all, let's hang in here. I'm not gonna go to sleep.
Families, victim, the family's victim, or, excuse me, the victim's
That's
family.
right.
And,
He's supporting the family fitness, which is Bryan. And Bryan not talking. Bryan want folks to talk to him. Oh Lord, let me hang out a minute.
and I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, Nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it will hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this, in the meetings that I have had with the prosecution's office, I have asked as part of that whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way, and they've never taken us up on it.
My thing is, that family had plenty of time, time, to get an attorney to talk to them. But they want to wait till this time doing the gag order to go get an attorney. Man, y'all playing games. Man, hurry up. I'm sleeping.
Maybe a random email here and there that says something and no follow-up whatsoever about anything. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people
Wait a minute. No, you can't tell the judge to do this because that's who it's about. How you gonna tell the judge to shut them up? Oh Lord. Let me hurry up. Let me skip this a little bit. Yeah, this man, y'all gonna say what y'all got to say. I got to go to work.
Thank you.
Thank you, Mr. Green. All right, well, I'm not going to issue a decision today. I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today. And I'll get back to work and try to get a decision out as soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
I don't think so, Your Honor.
Ms. Taylor? Mr. Watkins?
Why she don't talk?
Yeah, PR, we thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Thank you.
It remains in place until I address it.
That's right.
So, with that, we are adjourned. Thank you all.
That's right. Bye, Bryan. To yourself. All right, y'all. Let's talk about now. Look, it really everything it just explains itself. He just the family lawyer attorney wants to come in and make changes on the gag order, which he cannot do. And if they want, they knew way back that the family needed an attorney and everything. It's not about Bryan fam. It's about Bryan family being a witness for Bryan. That's different. You know what I mean? But the gag, they supposed to been did all of this before they put the gag order in place. So this is about the prosecution team and the defense. Y'all tell me what y'all think. Like, share, and subscribe. See y'all in the morning. I'm out.